Hello and welcome to this webinar masterclass on construction arbitration. I'm Robert Gaitskell and I practice as a Queen's Counsel in Keating Chambers in London. And we specialise in construction and engineering disputes and all the ancillary matters like procurement and so on. But what I'm going to be focusing on today is the nuts and bolts of getting a cost-effective construction arbitration. When things go wrong, the party that is on the receiving end of a claim has a huge incentive to delay things. He doesn't want to have this claim against him heard. And if it's uncitrol, there are many opportunities to delay things. For in-house counsel who are desperately keen to get the decision so that their company can then act on it, that's a good feature to look out for. Because if the liability claim fails, there won't need to be a quantum hearing, and so you've immediately saved a lot of weeks and therefore a lot of money. That saves all the photocopying, all the couriering of enormous bundles of documents around the world, and it means at the hearing itself things go much more quickly. You can make sure that all the evidence in chief is put into writing in the form of witness statements or experts' reports, and those are simply taken as the evidence in chief and cross-examined upon. An important way of making best use of the time available in the hearing is to adopt the chess clock arrangement. And that means pretty much what it says. It's too late then because they've already started the ball rolling on the wrong basis. In my experience, experts, particularly expert engineers, are very good at finding common ground on really tricky issues. That joint report identifying what's agreed, what's not agreed, is a good way of instructing the tribunal. That expert cannot pull the wool over the eyes of his opposite numbers. Far more effective is to think about that from the outset of the negotiations and to have what's generally called a tiered dispute resolution clause. If you have a dispute board in place right from the beginning, you can potentially avoid any arbitration at all. It walks the site, it sees what's there, it listens to the complaints, and it comes up with sensible ways for trying to resolve things before they crystallize into a real dispute. It is something that the parties themselves can choose, provided they do it at the point when they're writing into the contract the procedures they want. The effects can be dramatic because you can, as I've said, avoid any arbitration at the end of the day. If the other side end up getting less than X, then they suffer penalties in costs because they fail to take up your very sensible offer at an early stage.